Shuster is a founding partner of McMurray & Shuster, where she brings extensive experience in working with clients of all sizes involved in highly regulated industries. She has established a solid record of representing clients in consumer protection matters before state attorneys general, the FTC, and FCC, in addition to conducting regulatory compliance audits and providing counsel on advertising and privacy issues. Michelle currently serves as the General Counsel to PACE and oversees its self-regulatory organization program. In this role, and with her significant depth of experience related to TCPA compliance, she has been an integral part of PACE's current challenges to the FCC's TCPA order. She has an exceptional foundation in U.S. privacy laws and regulations and is accredited as both a certified information privacy professional through the International Association of Privacy Professionals and customer engagement compliance professional, or our CECP program, which is through PACE. And Ms. Lisa Messner. As litigation director at McMurray & Shuster, Lisa focuses her practice on the unique needs of businesses that are facing complex civil lawsuits. She has successfully defended businesses in highly regulated industries against class actions and government enforcement actions across the country. Lisa litigates in a variety of jurisdictions and has been specially admitted on a pro hoc vice basis to federal district courts, including Illinois, Texas, and California, where she defended a variety of complex lawsuits, as well as agency enforcement actions related to consumer protection laws and regulations. Lisa brings more than 17 years of litigation experience and utilizes a litigation process that focuses on a unique business model, culture, and goals of her client to craft a defense strategy specifically targeted to meet that client's goals. In addition to her litigation practice, she also assists clients with achieving industry and statutory compliance, conducting employee training, and proactively improving internal policies and procedures to minimize future litigation risk. Lisa has been recognized for her outstanding professional achievement as an Ohio Super Lawyer, Ohio Rising Stars for 4 years, an award, and that's an award that's given to less than 5% of all Ohio's lawyers. She has also earned recognition in the Columbus CEO magazine list of top Ohio lawyers. I will now turn the floor over to Lisa and Michelle.
Thanks, Chris, and thank you everyone for joining us today. I think this is a really interesting topic. It's a little bit different than the topics we've discussed in the past on these compliance GC webinars, but it's a topic that I am hearing more and more about from my clients, so I thought it important to bring to our PACE membership, and that's the potential for class-like actions in the employment setting. If you're paying attention to some of the stories in the legal magazines, you'll see that there have been a large number of wage and hour lawsuits that have been brought against companies, and that there has been a swing in the courts for the most part on the employee side, which is minimizing some of the defenses that employers have had in the past. So we thought this was a good time to update you and let you know where the biggest risk areas are and what types of things that you can do to increase compliance in your workforce or with your workforce in the call center. Before I turn it over to Lisa, I also wanted to say that we are planning our GC webinars for 2020 and really want to focus on providing webinars that are the most value for our members. So if you have any suggestions, any areas you'd like to hear about, don't hesitate to call me or email me. My contact information is on the PACE website, but it's mshuster@mslawgroup.com. Would love to hear from you about future GC webinars for 2020. And with that, Lisa, thank you so much for joining me today. I know how busy you are, and so I appreciate you taking the time to do that. I think this is a fascinating topic, and look forward to hearing what the latest and breaking latest news is out there from the trenches.
Yes, thanks to Michelle and Chris. That introduction, Chris, might have inflated my head a little bit as we get on to discussing this. But going back to your point, Michelle, this was a topic that Michelle and I have talked frequently in the office about, in presenting a lot of very unique issues to contact centers in specific. And interestingly enough, the way that the communications continued with Michelle and I, and we thought that we should bring this to the PACE membership, is just through doing simple Google searches. And so in doing Google searches about plaintiffs' employment practices, specifically plaintiff side attorneys that are practicing in this area, they are specifically targeting employees of contact centers. And we're going to talk about this a little bit later on in the webinar as well, and the Department of Labor is as well. So it's definitely a trending area, and it's definitely something that is important to get onto your radar now and think about what measures will help best protect your business from these issues. And so with that, I'll just provide a brief background into my knowledge in this area, and that for many years I did litigation on the plaintiff side on employment issues. My practice focused on that for about 5-6 years of my total litigation experience. And so I think that helps for me to speak to you, to bring you the unique perspective of kind of where plaintiffs' lawyers are coming from, and how you can best come into compliance to avoid them going forward. So that being said, I'm going to go straight into some of the topics that I wanted to cover, and we're going to leave some time for questions at the end. So as you think of things as we're going through these topics, please make note of your questions. The biggest issue that I think that we need to talk about in this realm is incentive compensation. And so I know that for many call centers, that the typical customer service representatives who are down in the trenches and answering calls or fielding calls are paid on an hourly basis. And that's an appropriate way to pay them. But with that, also, we want to incent these employees to be efficient, to close sales, to comply with certain objectives, possibly to even make sure they're complying with scripting requirements. And we do all those things so that we're complying with other laws, and that includes the TCPA and maybe state-specific laws, maybe certain requirements associated with a campaign to meet our clients' objectives, things like that. And so we will oftentimes see these particular customer service representatives receive some kind of incentive pay in addition to their hourly pay. And whether that's tied, like I said, to a sales objective or something else, they're paid a certain incentive if they meet a certain objective. And so when they are paid hourly, we all know that their hourly rate is multiplied by time and a half for hours worked over 40 in one work week. What people don't always think about or realize is that the incentive pay that an employee may receive should be included in that effective hourly rate. And so if a particular call center employee's rack rate is $15 an hour plus incentive pay, that incentive pay needs to be factored into that $15 an hour for purposes of overtime. And where this becomes a challenge for employers, I think, is that those things vary. Okay, so the incentive pay is going to vary from day to day and week to week, and that is going to make it difficult for computing that hourly rate going forward. And I would even go so far as to say that it's not only a challenge for employers, it seems to also be a challenge formulaically for the payroll processors. And so we've seen that to be the specific case is that albeit an employer has well-intentions and indicates to its payroll processor you should be including this incentive pay into the equation for any type of hourly rate that is triggered by overtime, the payroll processors will use a standard formula, but it doesn't account for the fact that incentive pay changes based on the employee's individual performance, which can vary from day to day, week to week, month to month. And so that literally can change their hourly rate, their effective hourly rate on a given time, and it's just an easy trap to fall into. And so one thing I would encourage everyone to do is to make sure that those conversations are being held with any third-party payroll processor. How are you making sure from a formula standpoint that you're complying with these very specific laws and that you are doing it on a week-to-week basis? So what the law is going to look at is how that pay is computed on each work week. And so if the incentive pay is paid on a monthly or a quarterly basis, it still needs to be broken down into a week-to-week computation. And so we should be making sure with any payroll processors that we use that their formulas account for the fact that it's somewhat of a moving target on the weekly pay amounts. And then the other part to the incentive pay is that oftentimes companies will have certain types of incentive drives where they're paying their employees incentives not through cash compensation but through some other mean, such as gift cards, or maybe there's even, I've seen where companies have done contests where they use leaderboards to pull for prizes that maybe aren't even gift cards. Maybe there's some other type of actual tangible prize. And technically, the value of those things should be computed into an employee's effective hourly rate for overtime compensation. And that's a pretty common trap because companies don't always even issue 1099s for those kinds of things. It's more in the nature of just employee morale, internal competition, and trying to drive a fun work environment. But those things are technically considered compensation. And again, the same trap applies in that those will vary from week to week and month to month. And so if you do engage in those kinds of awards of either gift cards or other prizes because you're having a specific kind of drive to see if you can increase sales, just make sure you account for those things. Those are things that your payroll processor, if you use one, should be able to help you with. If not, you should endeavor to place some kind of value on those items, issue 1099s for them, and make sure that the work week in which they are received by the employee, it is assigned to any hourly rate that they may have applied to them for any hours worked over 40 in one work week. Turning to what I think is trending as a really big issue right now for call centers and for employers at large, actually, are the what was typically considered under a de minimis exception of work, in that the work was considered to be 5 minutes or less and not a substantial amount of time, such that it should be compensable. The trend now is to kind of eradicate that de minimis exception, if you will, and to hold that this work is truly work off of the clock. Now, most commonly in call centers, that is going to be time associated with booting up a computer, putting on a headset, addressing any technical issues with that headset, taking down maybe starting notes or paperwork notes prior to logging in, and reading maybe a company memo before they've logged in, things like that. And I think that for call centers, where this really comes into play, and I've seen it in one case in particular come into play, is that the manner in which employees clock in and clock out are driven by their computer, are driven by logging into their computer. And so when they arrive at work, they're putting on their headset, they're adjusting sound, they're adjusting technical issues with the headset, they're booting up their computer. Maybe their computer is taking a while to boot up and log on, or maybe there are system issues with an employee actually logging in. And so by the time that that employee actually logs into the system, which assume under this system that's the point in time that they're clocked in for purposes of hours of work, they may have spent 5 or 10 minutes doing that. The law is no longer recognizing that time as de minimis. The trend in the law right now is to say that's compensable work time for which an employee needs to be paid. That would also apply to any type of meeting or required training programs that may happen during not work hours. Those things should be compensable as well. And then lastly, I wanted to point out something that I think that a lot of employers don't even think about, is that where there would be occasions that employees maybe get stuck on a particular call and they're working through a scheduled lunch break or through an unpaid rest period, and they're not necessarily even noting that time, but that time is compensable. And so employees really should be trained that if there would have that circumstance arise where maybe they're very close to completing a sale and that sale runs into their lunch period, that they should either make sure that they make note of that extra time that they've worked, or that they take a full 30-minute or 1 hour or whatever the scheduled period is for lunch, even if that means running over their normal time. And I think that tied into that a little bit is something that people should think about in terms of unpaid rest periods. And so an unpaid rest period has to, in order to be not compensable, in order to withhold pay from the employee for that time, has to be under the Department of Labor regulations. It has to be at least 20 minutes, and it has to be uninterrupted. And so think about an employee who maybe takes a break to smoke. Maybe there's employees who smoke cigarettes and they take a break to smoke, and that break is a 10-minute break. That still is compensable time. It is not of sufficient time to dock that employee's pay. If the employee takes a 20-minute smoke break but is interrupted by his or her supervisor for a question about a call or a campaign or something associated with work, that break has been interrupted, and again, it is not something for which then compensation can be withheld. And I think that that's a pretty handy rule of thumb for employers to keep in mind, that 20-minute period, because it's close to a lunch period, but it's not really there. And I think that a lot of places that I have seen that have fallen short on compliance on this point have scheduled 2 15-minute breaks during the day and then maybe a 30-minute lunch period, and they dock an employee for an entire hour of pay during the regular workday to account for that time. The 2 15-minute breaks are not of sufficient length to not be compensable. And so when you take all of those things together, that is something that oftentimes we see plaintiffs' lawyers plead in a complaint as working off the clock. This employer had employees performing work off of the clock, and that time should be compensable. And the snapshot of that is, while it seems like the time overarchingly is de minimis, the statute of limitations to go back on pay can be up to 3 years. And so if we think of upwards of 10 to 15 minutes a day over a course of 3 years, how much time that could add up to, and then also factor in that under most state laws and under the federal Fair Labor Standards Act, any violation triggers what's called liquidated damages, which means you have to pay double the amount of pay to that employee as a penalty, the time really can add up. And if we're looking at possibly adding, if we get one plaintiff and they're able to add other people into a lawsuit, it really can become a large amount of liability very fast. And so that ties into the next thing I want to talk about is, costly mistakes and how those happen. And so we've talked about some of the pitfalls that employers may face, and I talked a little bit about liquidated damages. Another thing that is important to keep in mind is that under most state laws, there are going to be what I call piggyback laws, but tandem laws that apply an additional penalty on top of what the federal law applies, which is going to be double damages for a period of up to 3 years. And then the federal law also has a mandatory award of attorney's fees. It's not discretionary, it's mandatory. If there is found to be a violation of any of these wage and hour laws, an attorney's fees award is mandatory. And then most state laws have similar language mandating that award of attorney's fees. And then in addition, the federal law also allows for a certain type of class action lawsuit to be brought under the statute governing the requirement of full compensation and overtime pay. And it's a little bit unique to class actions. I'm sure that many people in PACE are familiar with class actions under TCPA, where it's an opt-out type of scenario where everybody's in the class unless they affirmatively opt out. The employee requirements are that employees must opt in or they're not included as part of the class. And where that becomes problematic is that that courts often require the employer to then notify all of its employees of any type of potential liability, current and former. And that sometimes I have seen really opens Pandora's box. Current employees, I think oftentimes are reluctant to join in a lawsuit, out of maybe loyalty to the company, and so then their liability can still be hanging out there. And then employees maybe who are disgruntled might have, an axe to grind, if you will, and opt into the case and maybe overstate, if you will, the facts surrounding what the unpaid time might be. And so all of those things together can really create a scenario for companies that can be crushing, that any type of small to medium-sized company could not even withstand that type of liability. The next, probably most common thing that we see employers fall short on is the failure to classify its call center employees correctly as either exempt or not exempt from the federal overtime payment laws. And so it's interesting because as we go through a structure of call centers, we oftentimes see that we have our customer service reps, then we have a team leader, or maybe we have a working manager, or maybe we have a true manager. But some of the higher level employees, as they work through the ranks and work their way up, can obtain a title that might make them, by the title, appear to be exempt from an overtime pay law because they're in some kind of management capacity. But if they are actually performing more work that would align with being a customer service representative, and that would, a rule of thumb would be 80% or more of their duties encompass that, that is not going to be legally sufficient to qualify them as a manager, and they still should be paid on an hourly basis. And so one thing that I would recommend is that you really take a look at a job title and a job description and you take a look at what the employee is doing day in and day out. And we should be verifying what 80% of their time is spent doing. And if 80% of that time is spent actually managing employees, then it is safe to classify them as exempt. If that is not the case, then you really need to take a look at reevaluating whether they should be paid on an hourly basis. And I think that is particularly true for folks who work at that team lead kind of level where they're really a working manager. Those folks really should be paid on an hourly basis and not classified as exempt from overtime. And so at the beginning of the presentation, I had alluded to the fact that what we were seeing trending was a heightened degree of oversight by the Department of Labor, particularly as to call centers. And it's interesting because the Department of Labor has publicly identified call centers as problematic. They have done a fact sheet, which I will show you on the next slide, to indicate that this is a particular industry that has been identified as problematic. Their fact sheet spells out for employees things to watch out for. I think that this has made call centers a potential target of the Department of Labor. We've seen a lot of Department of Labor audits of this industry, and those types of audits are very crushing. The Department of Labor has very broad investigative powers. They have the full authority to come in and request all of your payroll records, all of your timekeeping records, all of that type of information related to hourly employees or even employees that the Department of Labor thinks may be classified as hourly. And they can request all of those records for a period of 3 years, and they can look and see if there were any violations. If there were, the Department of Labor has the right to come back on the company and demand restitution paid to the employees, to demand liquidated damages be paid to the employees. That's the double amount owed to them, and to pay for the cost of any investigation by the Department of Labor. And so it can be very expansive with the types of power that the Department of Labor has. And the Department of Labor has information that is very publicly available for employees to very easily be able to make a complaint. And that process is so easy now that employees can do it on the, or former employees can do it on the internet. They don't even have to talk to a person. And then that can trigger an investigation by the DOL in and of itself. And so this is the fact sheet. It's fact sheet 64, and it's specific to call centers. And you can take a look at it, and it's publicly available on the internet. And I'm sure that if anybody would like a copy of the slides so they can have a copy of this particular fact sheet, they're welcome to do that. But you'll see in there that it covers a lot of the material that I talked about today. It does point out that the particular federal law does require a certain volume of business before it is triggered. However, I would caution you that even in the absence of that volume of business, there's going to be a lot of state laws that have the same or very similar requirements as this law, and they're going to require a much less volume of work. And so by way of example, Ohio, the state that in which our law firm is resident, has a law that applies all of the standards of this federal law, and it applies to anybody with 4 or more employees. There's no volume requirement. And so you can see that the state law has come in to kind of fill that void to capture smaller companies as well. And so they talk in this fact sheet about the same requirements I did about any hours over 40 in a work week need to be compensated at 1/2 times the regular rate of pay. They talk about the rest periods, the bona fide meal periods being able to be deducted. They talk about the rest period of 20 minutes, 20 minutes being that triggering time for which you can deduct. And then they talk about hours worked, which includes time before and after that may be what we would consider de minimis, but it still should be compensable work time. And then another thing that I wanted to mention that's on this fact sheet that I don't know I have raised before is record keeping. It's very important for employers to make sure they're keeping adequate, complete, and accurate records of all hours the employees work. And this would include pre- and post-shift activities to the extent that even they exceed a couple of minutes, they should somehow, you should somehow find a way to record those. An easy way to do it would be simply by maybe a key card entry to an employee coming in and out of the building. That might be one way to do it that would kind of get around that issue of employees logging into the computer. And at least if you maintain those records, it would keep that kind of record-keeping requirement. And although the statute of limitations under this law only goes back 3 years, and under most state laws it only goes back 3 years, I think a best business practice is probably to keep your records for at least a period of 7 years. And this would protect you from any allegation of like a pattern and practice or some kind of systemic, allegation that the company had been engaged for an extended period of time in this activity, even though beyond the statute of limitations. And so if you need more information about record-keeping requirements, either Michelle or I'd be happy to talk to anybody about that, because oftentimes it needs to be tailored to the specific nature of the business. But that's just something I think that is important to keep on a company's radar, is that the hours of work for employees need to be maintained and in an accurate way. And just as an aside, that's very significant from a legal standpoint in terms of the record keeping, because in the absence of accurate records showing the actual hours your employees worked, the law will make a presumption that what the employee basically states or estimates to be their hours of work will control then in the absence of those records. So they obviously become extremely important in either a DOL audit or a litigation standpoint. And so that would conclude my prepared remarks. I would be happy to answer any questions that anyone might have.
I will just remind everyone that you can ask questions of Lisa or even Michelle by using the chat box on the right-hand side of your screen. But Lisa, we do have a couple of questions, though. This is a very broad question, but bottom line, what is a company's biggest risk?
Yeah, so I guess I would start by saying I think that that from my standpoint, the biggest risk out there is the failure to keep those accurate timekeeping records. I think it is the thought by many people that hours worked, if you will, before and after the shift, such as putting on your headset and things like that, are de minimis and not compensable. I think that those things kind of falling off of someone's radar are the biggest risk for target. In addition, this is very interesting because in preparing for this, I just did a Google search on call centers and employment practices and Fair Labor Standards Act, different kinds of terms like that. And the first 3 things that popped up were plaintiffs' lawyers soliciting for employees in call centers for class action type of litigation. And so I think that that just exemplifies that this is a targeted industry right now. And so I think all those things together probably collectively identify the biggest risks. Michelle, I don't know, you work a lot with folks in this space. What are your thoughts on that?
Yeah, no, I agree. I think that, some of the cases that we have seen lately and that we have been involved with really deal with this overtime issue. And while calculating overtime seems like an easy an easy task for companies. As Lisa pointed out in the presentation, there are so many factors to consider in this, and I think the case recently against Starbucks is a good example, although not in the call center setting, but shows what type of pitfalls there are out there for employers. And in the Starbucks case, there was time by both employees and managers that they were either preparing for their shift or cleaning up for their shift, and it's my understanding that they weren't being compensated for that time, and therefore were entitled to compensation, and frequently that was also overtime compensation. So led to a pretty significant judgment here in the last couple of weeks against Starbucks. So I think that's an issue that we have to keep in mind and make sure that our payroll folks and our HR departments understand it's an issue that we have to get right, because if it's not right, then we're looking at a class that entitles employees to be compensated and also to have their attorney's fees paid for. So there's strong motivation here for plaintiffs' attorneys to get involved in these types of lawsuits and to seek out call center employees to initiate these types of lawsuits.
That's great. Well, not great, but those are great examples. There we go. It is close to a Friday today. There you go.
We understood what you meant, Chris.
All right. So
Chris, it is Friday Eve.
Well, there you go. There you go. I'll take that.
Right.
The next question we have, and I think you did cover it somewhat, Lisa, but just like all in a nice little box, what type of records should companies be keeping and for how long?
Yeah, so for how long, I recommend 7 years, which I did kind of talk about during the presentation. In terms of type, I think that has to vary and be tailored to the business, but if you have a third party doing your payroll, that is something that I think most of them offer as either an add-on service or a part of the service you already pay for. And so I would start there because if nothing else, the payroll processors can help you figure out how to track that. And I think along with that, that companies need to make sure with their record keeping that they're really making sure that it's accurate. Because just saying, well, our payroll processor have records of the time that you logged into the computer and logged out, there can be a challenge on the accuracy of those records from employees saying, well, I didn't have a full break here, or I did 10 minutes of work before I actually logged into the computer that day, or we had a mandatory 30-minute meeting before work that day. And then that becomes into the space of, well, your records aren't accurate, so we're not going to rely on them. We're just going to rely on what the employees say. And that can obviously create a lot of problems. And so that's why I say go to the payroll processor, figure out how they're tracking employees' hours, and maybe look at a system where the actual hours are somehow recorded for the time of entry into the building of the employee. And don't ever minimize just having employees have to fill in manual timesheets on a week-by-week basis. What better evidence to refute an employee's allegation that they worked 50 hours in a week other than to have their own notes indicating that they only worked 40? And so those are at least some options available, but I definitely would encourage companies to contact their payroll processing centers and see, what services might be offered as part of what you're already paying for to help track those records and to store them.
That makes a lot of sense. So the next question that we have, and this kind of goes along with it, are there any types of policies or procedures that a company could implement now to better protect themselves?
Yeah, I think that that one thing would be to have a very strict timekeeping policy indicating that the employees are required to accurately enter their hours of work, and that whatever mechanism that particular employer is using for recording hours of work to indicate that the employee understands and acknowledges that he or she has an obligation to be honest in reporting their time, and that even if there is a policy against, say, unapproved overtime, if that employee works overtime that's not been approved, that they will still so note that the law requires the company to keep those types of records, and that that there be a policy of honesty by the employee, and I would maybe even do it as a separate policy that each employee specifically has to sign off on, because again, then it's putting back on them an obligation to be honest, and not come back later on and say, well, the company says that we're to record our hours, but they didn't really have policies and they didn't really want us to do that. That's one way to show, I think, a level of seriousness on it. And I think that it also goes the other way, that if employee has maybe to be called away from work for an emergency, that they're equally obligated to report that they have left work for the day and things like that. So there can be a lot of side benefits to having such a policy.
Okay, wonderful. Are there any, the last question that we have right now is, just in general, how can a company best protect themselves going forward with everything, other than like the policies and that type of thing? Is there anything else that they should be doing?
I think the policies, the record keeping, I think having a level of transparency with employees, that the company takes it serious, that they, that we want to make sure employees are paid for all of their time in fairness, that we in earnest want to provide them incentive pay, that we have an acknowledgement of what the law requires, and that it's our intent to comply with that. I think that all of those things from policy, standpoint are helpful to protect themselves. And then, obviously, if you're not sure, consult with an attorney. I think that to consult with your payroll processing company to make sure there's transparency on how they're computing your overtime is something that is helpful to protect. And possibly even taking a look at the contract that you may have with your payroll processor. Does that contract afford some type of right for the company to go back on the payroll processor for some kind of indemnity if they're not meeting their obligations? Because maybe the strength of that kind of a contract would add a little more credence into what the payroll processor is doing and what level of compliance they're ensuring that they're meeting. Those are all kinds of things, I think. Michelle, do you have anything else you would add to that?
No, I think that's it. And Chris, do we have any additional questions?
This is actually a question from me, and just because I'm not as knowledgeable in the labor type side of the house, are there audits that you can do to ensure that the policies and procedures are being followed, that payroll is being paid out accordingly, all those types of things?
So, Lisa, I think, I'm sorry, go ahead.
No, I was going to ask if you wanted to answer that. I mean, the short answer to that question is yes, and then Lisa, if you want to elaborate on what those look like.
Yeah, so back to Michelle, yeah, the short answer is yes, and I think that the audit procedures are depending on how the payroll is done, but I think that oftentimes they start with your payroll processor. What formulas are used? And then I think that it requires, an audit against employees. What is their title? What are their actual duties? Do the duties that the employees perform on a day-to-day basis match what our job descriptions are? Do we have those kinds of things that maybe we need updated? I think that break periods, need to be looked at. And so I think that the primary way you would audit is you would have to have somebody almost come on site and do a private version of what the Department of Labor does in terms of an audit. And so they would view different classifications of what employees do, what their actual work are, versus what their job description is, how are they being paid. I think that they would be looking at break periods, they would be looking at the incentive pay, how that works and whether it's being measured on a week-to-week basis. And then I think that the record keeping would have to be audited in how the records are being kept and whether that's accurately tracking the true hours the employees are working. I think it's all those things taken together.
That makes a lot of sense. All right, well, that looks like that was the last question that we had. So I would like to thank again Michelle and Lisa for this very informative webinar. As I said at the beginning, the recording of the webinar will be available on the PACE website in just a few days. And to remind you all, the 2019 Washington Summit will be held September 22nd through the 24th at the Intercontinental on the Wharf in Washington, D.C. Our early bird registration is open until close of business tomorrow. So you want to make sure that you register now if you haven't so that you can take advantage of that discounted rate. And also our hotel room block expires on August 28th. We won't be able to guarantee a room or the PACE rate after that date, so please make your reservation now. And additional details about the summit can be found on the PACE website. Again, thank you, ladies, very much. We appreciate it. We hope to see you all at another PACE webinar, national, regional, or chapter event very soon. Thank you, everyone, for your time, and have a great rest of your day.
Thanks, Chris. Bye.
Thank you.
Bye, everyone.